the jury on Mr. Brammer's requested instruction on proximate cause that stated that Mr. Brammer had to be the proximate cause of Mr. White's death in order to find him guilty. Specifically, the requested instruction contained 2 paragraphs, the first of which the district court did provide, and the second paragraph, which was not given, which read that while contributory negligence is no defense in a prosecution for a driving offense of involuntary manslaughter, it's a circumstance to be considered along with all the other evidence to determine whether Jason Brammer's conduct was or was not the proximate cause of Taylor White's death. You may consider the conduct of Taylor White to determine if his contributory negligence may have been a substantial factor in his death. In this case, first I would like to discuss whether or not there was error, specifically whether or not the requested instruction was legally and factually appropriate in this case, and whether the district court erred in whether it was error not to give it. Mr. Brammer has the right to the instruction on the law applicable to his defense, and if there was evidence to support that theory, when viewed in a light most favorable to him.
Why do you get that standard as opposed to clear error?
Yes, in this case, we argued in our brief that it was requested and not given based on the request, whereas the district court did find that it wasn't requested. In this case, the statutory requirement, the statute requires that all parties file either written requests or make oral requests for whatever instructions they would like to be given. And then the statute states that the court would give the instructions as requested, refuse to give the requested instruction, or give the requested instruction with modification. That's KSA 2234-14, subsection 3. However, in this case, Mr. Brammer filed his written instructions, and the court refused to give the instruction as requested, and instead gave it as modification.
Refused at the time of the instruction conference, did it? It wasn't the situation that the requested instructions were filed a month before trial or something, sometime before trial. And then at the time of the instructions conference, when the judge indicated it was the time to either object or suggest additions, defense counsel declined to do either. Isn't that correct?
Yes, that is correct. However, our argument is that the Court of Appeals, in finding that at that time, by failing to re-raise an objection to not giving his instruction, the Court of Appeals is reading into the statute a requirement that's not there. The requirement is to either to file written requests or file oral requests.
Yeah, but that's not true, because the statute goes further and talks about how objections are to be distinctly stated, and then be made on the record with the court reporter and the court ruling on them. And that didn't happen here with any of these other instructions, did it?
No, it did not. The argument is that while the statute does talk about ruling on objections, there's no requirement in the statute that says contemporaneous objections need to be raised if you filed your written request or your oral request at the instructions conference. The requirement is file your written request, file or make an oral request for an instruction, and then the court will either give the instructions as requested, refuse to give the requested instruction.
I think the statute goes further and talks about distinctly making your objection, and so I don't think you're not convincing me yet that
right.
That I'm not saying this is an invited error like the Court of Appeals. I'm really just trying to figure out the standard of review for these questions. So.
By my recollection, I apologize, I don't have the statute in front of me. The final paragraph in that subsection does talk about where the clearly erroneous standard arises, as if you don't, make objections, timely objections, if it's not raised before the court. our argument is that by filing a written request and the district court not giving the requested instruction as requested, that is timely raising the argument that this is the instruction we want. If you don't give it, we don't agree with the decision.
Let me move you over to the substance. I guess I understand your position there. On the causation instruction, you had 2 paragraphs. Now, in the first paragraph, the Court of Appeals pointed out that the defendant's proposed instruction, which was used, had transposed the decedent's name for the defendant's name, and there's no issue about that in this appeal, is there?
No, there is not.
So we're focused on the second paragraph, and you pull that from State versus Chastain.
Yes, that's where the request is.
And as I read Chastain, and this is what's bugging me, so that's what I want you to respond to. As I read Chastain, the second paragraph that you want in the instruction is quoted by the court as the justification for why the first paragraph sufficiently states the law, as opposed to being another paragraph that adds additional elements or something else. So why does leaving out the second paragraph mean anything in terms of sufficiently instructing the jury?
Yes. And that is what the Court of Appeals focused on as well, was that it was more just clarifying information and not something approved of by this court as an instruction. However, the second paragraph, it does contain more information than the first paragraph, even transposing the names. Looking at Mr. Brammer's fault and whether or not he was the direct cause. The second paragraph talks about the circumstances surrounding contributory negligence and whether or not Mr. White's conduct also contributed. Whereas in the first paragraph, it only talks about Mr. Brammer's conduct. It does not talk about considering Mr. White's conduct.
Is that true? Because my recollection of the first paragraph is that it tells the jury to look at all the circumstances. So it really does, it seems to me, throw a net around all the evidence that the jury heard in the course of the trial, and not just focus on the decedent or Mr. Brammer, depending on how that was written. But it really is focusing on all the other evidence sort of thing. So again, why isn't that sufficient?
I think in this case it's insufficient because of the defendant's, the focus of the defense counsel during the trial on those other circumstances and how those contributed to the death. And so consider it's circumstances that were specifically pointed to by the defense are discussed specifically by the second paragraph. Therefore, it is talking not only about Mr. Brammer's conduct, not only about the general evidentiary issues, but as well as the specific conduct of Mr. White on the day of the accident. And so this, our argument is that this paragraph is both legally and factually appropriate to these circumstances based on the way that the defense counsel presented their case, and that the first paragraph does not encompass everything that is in this second paragraph.
Doesn't it leave room for argument by defense counsel, though? By in that first paragraph, by talking about with all of the other evidence, isn't that sufficient for defense counsel to then add to that? But some of the other evidence is these negligence acts by Taylor White.
I can see how, I mean, our argument would be that for the particular circumstances discussed in the second paragraph, that's too broad to focus on what contributory negligence was, focusing on all the evidence when the focus of the defense was these contributory negligence factors, makes the first paragraph insufficient without the second paragraph. And that with even looking at the clearly erroneous standard, the failure to give, if this instruction was given as requested, this court could be firmly convinced that the jury could reach a different verdict if this information is provided as requested, based on the specific incidences that Mr. Brammer's counsel discussed and focused on during evidence, specifically Mr. White's conduct during when the accident occurred. And the jury could have considered all of that cumulative evidence specifically related to Mr. White's conduct to show that those were superseding causes that might have made Mr. Brammer not actually criminally liable for the charged offense of driving while intoxicated, involuntary manslaughter. I see that my time is up.
I've got another question. If I can focus your attention on your alternative means argument from the instruction. Last year in State versus Cheffin, in relation to the felony murder statute, we found that the statutory language in the commission of, or attempt to commit, or flight describes factual circumstances. Is there any reason why that ruling doesn't impact the involuntary manslaughter DUI conviction that your client got?
Well, at this point in time, before this court, the argument would be that this court does not even reach that issue. The Court of Appeals in this case did not rule on whether this crime was in fact alternative means. They resolved the issue without even deciding that case based on the instruction, the elements of instruction in the verdict form. And so they didn't even reach the question of whether or not this crime constitutes alternative means, and our petition discusses whether or not they applied the right standard in saying that the verdict form resolves all those issues.
Well, if we don't even bother with the verdict form argument and just go straight to the bottom line, do we really have an alternative means problem given Cheffin?
I think that there is an argument that based on that case that issue is resolved. However, the State v. Shaw is still out there as well, in which the exact same elements were found to be alternative means. I know that's a Court of Appeals decision which was denied review by this court, but there's still those conflicting opinions, and we would argue that State v. Shaw is still the good law that needs to be followed in lieu of State v. Cheffin on this particular offense.
Any more questions? Thank you, counsel.
May it please the court, Laura Johnson McNish, Marshall County Attorney, appearing on behalf of the state of Kansas, appellee in this matter. I was prepared to discuss flight a lot more, especially after the Chatham case. Seems like that's kind of a winning argument for me right now. But to address the jury instruction issue, I do believe that the Court of Appeals handled that issue well. I do believe at the court that the standard is clearly erroneous.
If we're going to focus, excuse me, counsel, if we're going to focus on the way the Court of Appeals looked at that, do we really want to get into the failure to object being invited error versus just a failure to object?
No, I don't want to get into that. Thank you. But the jury instructions on proximate cause, I think they did make a good point that the issue in this case had more to do, very little to do with Taylor White's actions at all. He was tested. He had no alcohol in his system. If you recall the facts of the case, T.J. Martin had driven fast by him coming the other way. Hunter Lindeen was a passenger in Taylor White's car. He lived. Hunter said that Taylor White had pulled over carefully after that near miss and then had gradually gotten back on the road when the crash happened. So,
are you saying it's not factually appropriate then?
I think that given the facts, the instructions were just fine because they focused on other circumstantial evidence. This was a gravel road, there was dust. That was the argument the defense.
But isn't the point that we let the jury decide those things instead of the trial court deciding who wins?
Well, I think the jury did a good job in this case. They heard those facts and they knew how to deal with them.
But how did they know that they could consider the decedent's actions? I mean, we used the wrong name in the first paragraph and then didn't give the second paragraph. And the second paragraph's the only place I see that would have told the jury that the actions of the victim may be considered by the jury. I mean, where else was the jury told that they could consider the victim's actions as part of the calculus?
It's brought up earlier under the broad other circumstantial evidence you consider as a whole.
And okay, you mean in the first paragraph?
Yes.
You're saying that with all the other evidence, that's what brought in the concept of contributory negligence, and
well,
we would expect the lay jury to divine from all other evidence that there's the concept of contributory negligence involved.
Well, I think that the instructions overall, combined with the facts in the case, the jury's able to handle it. I mean, what did Taylor White do that was so compelling in the way of evidence that would have merited the instruction being different? I think that the overall circumstances was enough. I think the instructions in this case fit the facts of the case. And I think there's very little chance if it went back down with a different instruction, you're going to get any different result.
The one investigating officer testified that the collision took place in about the center of the road, correct?
I believe Trooper Herder testified along those lines, approximately. They keep using the word approximately the center of the road.
Okay.
But as I said, Hunter Lindeen was a passenger in the vehicle, and he talked about T.J. Martin flying by him, and that that was a near miss. And most people were more careful after that.
Excuse me, counsel.
Yes.
You were, I think, agreeing with Justice Biles earlier that you did not necessarily want to go down the road that the Court of Appeals took on the jury instruction. What is your road as to what our standard of review is and why?
The standard of review, I believe, is the instruction clearly erroneous? Only if the reviewing court reaches a firm conviction that absent the alleged error, there's a real possibility the jury would have returned a different verdict.
And why is that our standard of review in your estimation?
Because we can trust juries to do their job.
Well, why would it be that particular standard versus another?
Because our system is built on jurors. Our system is built on lay people making decisions about whether crimes occurred or not. So the court will not step in and undermine a jury's decision unless it's clearly erroneous. They weren't there, they didn't hear all the witnesses firsthand.
It's your position that that is the standard of review that we always use on alleged jury instruction error?
That is what I found and prepared the response brief using that test.
I think Justice Ness is trying, Chief Justice Ness is trying to ask you about the legal standard, not about the policy behind the legal standard.
Okay.
And isn't the reason that you're asserting clearly erroneous is the standard because there was a proposed instruction that was never spoken of again? In essence, whatever
Well, there's
objection.
certainly that aspect.
Excuse me, just a minute, I'm not quite done with my question.
I'm sorry.
Because in essence, whatever objection existed or whatever suggestion existed was waived at the time of the instructions conference?
There is
Or
certainly that
surrendered.
aspect.
Yeah. Okay, thank you.
Is that accurate that defendant did not ever object to the omission of the requested second paragraph?
As far as I could tell, looking back, that is accurate. Of course, it wasn't in PIC. I think what he was proposing was not part of PIC either.
My understanding of your opposing counsel's argument is that when the defense lawyer submitted proposed instructions and did nothing more, that was sufficient to preserve the issue for us to review and for us not to use the clearly erroneous standard. We'd be using a better standard for her. Is that your understanding?
That's not my understanding of the law. My understanding of the law.
I'm asking if that is your understanding of her position.
Of the state appellate defender's position.
Yes.
Yes, that would be my understanding of her position.
And why do you disagree with that?
Because the defendant may have changed their mind. They may have considered, well, my greater argument is the dust in the road anyway, so I want to leave the instruction as it is to emphasize that. At some point, too, these cases have to be done.
Would it also be your position that once you've submitted the instruction, if it's not given by the court, that counsel should be objecting to the omission?
Absolutely.
All right. That concludes my questions. Do you have any further presentation for us?
Really, I prepared to talk about flight in terms of DUI manslaughter today. If the court is confident that cases of Chatham, Perkins, Ahern are going to dispose of alternative means here in terms of the DUI manslaughter, then I need go no further. But I had really prepared on that issue. So do you wish to hear any presentation on that with respect to this case?
Well, I don't know that a majority of this court has told you that we think that Cheffin controls. So if you have arguments, you might want to take advantage of your remaining time.
Thank you. I would point out, just as a preliminary matter, that although the defendant states that the state did not argue alternative means in the response brief, that was done on pages 8 through 10, and we attached unpublished decisions, including Ahern. A lot has changed since then. I'd like to specifically deal with the issue of flight, as the court stated in Brown. First, that you will look at the legislator and the legislative intent by looking at statutory structure. The statutory structure in this case, we're looking at involuntary manslaughter, really rests in two statutes. 21-3442, the involuntary manslaughter by driving under the influence, and 21-3404, involuntary manslaughter by other means, including other felonies that are not inherently dangerous. When read together, these two statutes present 4 ways to commit involuntary manslaughter, and I laid that out on page 4 of the supplemental brief, the 4 different ways that it appears the legislature thought involuntary manslaughter could be committed. Another clue that the words in the commission of and flight from are just factual circumstances under which a material element can be proven is the fact that there's 2 tiers of this language in involuntary manslaughter, driving under the influence. One in the involuntary manner or manslaughter statute itself, and another tier of that language, attempt, operate, and flight from in the DUI statute. I look back at the case of Shaw, and I see that the Court of Appeals noted the Kansas Supreme Court has treated flight as coming after a completed crime, not an ongoing crime. The Court of Appeals further said there must be evidence of a separate flight from the crime of DUI to support a conviction under the alternative means. And I'd like to examine that. When you have a involuntary manslaughter from a crime such as damaging offense, and at the time of this offense that would have been in 21-3404B, felony damage of offense, you can run into the fence, you can tear it down, and you can leave the scene after you completed the crime. Most defendants, of course, do leave the scene after completing a crime. They don't want to be caught there. So a perpetrator could actually kill someone when they crash into the fence and don't see them on the other side, or they could kill someone when they leave the scene, 3 or 4 blocks down the road, hit a pedestrian. But when we look at the DUI manslaughter, driving under the influence is a continuous process. It's, if you will, an ongoing crime. How do you complete the crime of driving drunk and then engage in an entirely separate act of fleeing? They're simultaneous. Flight from the crime of DUI does not appear to be a distinct way of committing DUI manslaughter. I agree the phrase in the commission of beside the phrase in flight from would imply that flight occurs after a crime is completed, like in the case of the damaged fence. But in the case of DUI manslaughter, the sobering fact is the crime's completed only after a deadly crash. And so then we're seeing evidence like we saw in this case of the defendant trying to move out of the driver's seat into the passenger seat, of the defendant telling Hunter Lundeen, don't call the cops, I don't want the cops involved, or something to that effect. When he's treated at the hospital, he tells the nurse, F off. These are all evidence of guilty conscience. It's evidence that the defendant's flight or attempted flight show the commission of the act charged. And that leads me to the whole point this court made in State versus Brown. Merely describing a circumstance that would prove the crime does not create an alternative means. So to me, looking at State versus Phillips, when you say evidence of a defendant's flight can be evidence of the crime charged, and you've seen a lot of crimes, and you've seen a lot of flight evidence, that dovetails right into State versus Brown. So I would submit to you that flight in terms of DUI manslaughter is not a material element. It's a factual circumstance that would prove the crime. Very briefly, I do want to distinguish this case from Shaw. As defense counsel pointed out, the verdict form in Brammer was clear and concise. It was really boiled down, and the Court of Appeals kind of relayed that, set it out in that decision. We, the jury, find the defendant guilty of involuntary manslaughter while driving under the influence of alcohol with an alcohol concentration of 0.08 or more. The jury was polled, that's on the record, and they were unanimous. So our case is different from Shaw. In addition, we did have flight evidence. We viewed him trying to move into the driver's seat, trying to leave the car, but he was pinned in and couldn't leave it. Telling him, don't call the cops. those things were flight evidence tending to show that he knew he was drunk when that crash happened. Thirdly, there are less controverted facts in our case, I believe, primarily because we did see our Taylor White pulling over to the side of the road, taking caution before getting back on, and then the crash happened. Thank you for the opportunity to be heard on this today. Sorry I was a little bumpy on the jury instruction. I really was anticipating this would be much more about alternative means. So thank you.
Any further questions of counsel? Thank you. You reserve 3 minutes for rebuttal.
Yes. I would like to just go back to the discussion on the proximate cause jury instruction. I know there's some discussion about whether or not the standard is clearly erroneous or the more favorable standard review for Mr. Brammer. Our argument is that under either standard, Mr. Brammer should win and this should be remanded. However, there's the difference between these two, the instruction that was given and the instruction that was requested, talking about what this second paragraph entails, looking at what the prosecutor, what the state said in their closing argument, and focus on in their closing argument, was that the mere fact that Mr. Brammer was driving while drunk was enough in this case.
What is I'm sorry to interrupt, but can you give the best summary? What's the best evidence for your client with respect to contributory negligence? In other words, if we agree with your argument, if this court agrees that the jury should have been instructed on contributory negligence and that was error, what's the best argument or the best evidence that would tend to show that you may be able to meet the clear error standard?
Okay. The best evidence that I have is that although this applied to Mr. Brammer, Mr. White made no movement to leave the road. He made no evasive maneuvers, seeing somebody coming close to him, and there was evidence that he was driving also at a high rate of speed in significantly impaired conditions, and he was not wearing a seatbelt at the time of the accident. And each of those facts was enough to be a superseding cause to show that he was contributory.
So you have high rate of speed, and when you talked about the conditions, are you talking about the road conditions, right?
Yes, the visual conditions.
You're not arguing that the decedent was impaired. You're saying the road conditions were not
the
not
road
ideal.
conditions, yes.
And that he wasn't wearing a seatbelt.
Yes, that each of those is a superseding cause that could have contributed to Mr.
Are there
White's
any
death.
other facts that would support that argument?
Those are the main facts, but I believe that it needs to be given because those are substantially the same facts as were presented with Mr. Brammer as well. All that you add there is that Mr. Brammer came back with a 0.11 blood alcohol content, and the state told the jury that common sense should rule the day and that Mr. White met with a drunk driver and he's dead because the guy was drunk. That's the only, they told the jury that the only reason, the jury could infer from that the only reason that Mr. Brammer is guilty of involuntary manslaughter of Taylor White is because of the mere fact that he was drunk, despite the fact that the other factors that were involved applied to both drivers.
Were you prevented from arguing just what you stated as were some of the factors that the jury could have considered? Wasn't that argued at trial? Or were you, I mean, the jury instruction as given in the first paragraph didn't prevent presenting those factors that you just stated?
No, but when the jury instruction is given, that's the law that they are looking at, and I believe that the second paragraph specifically focuses on the contributory negligence issue, which was the argument, and it's legally and factually appropriate in this case, and it should have been given because that's the focus of this. And as was stated earlier, perhaps the transposition of the names, which admittedly was defense counsel's.
I was just going to ask, how did that happen? The transposition, that was the requested instruction, wasn't it?
Yes.
With
and so,
Mr. Brammer's name.
Right. And so looking at these two together with the transposed name, that the first one doesn't talk about what Mr. White's fault would have been in this case. The second paragraph is where it's talking about Mr. White's fault in this case. And although that is the requested instruction of Mr. Brammer, the argument is that the second paragraph was included in order to add in Mr. White's fault.
Had White's name been included in the first paragraph, as it probably should have been, that would have been sufficient to instruct the jury on their ability to consider his contributory negligence.
I still believe that the second paragraph is necessary to focus on the specific issues of contributory negligence.
How do we reconcile that argument with the closing argument of the defendant, which, as I recall, was counsel saying, this was just an accident. I'm not arguing fault by anybody. It was just an accident. Now, that's what I remember of that. Do I have that wrong?
That is.
So if that's the argument of the defense, how do we get anywhere near harmful on this? I mean, counsel just said, we're not arguing anybody's at fault. This is just an accident.
I think that you get to harmfulness because of the state's argument that Mr. Brammer was at fault. And that if you're looking only at Mr. Brammer's fault here, if you're looking at only the state's argument that Mr. Brammer's the one at fault, Taylor White is not at fault. Taylor White drove on the wrong road on the wrong day. He was just an innocent kid who met with a drunk driver. I think that this instruction is appropriate, even if defense counsel's argument says, we believe that no one was at fault, that it was an accident. The fact that Mr. Brammer was charged with this crime and that is being alleged to have been at fault is enough to talk about, okay, what other things might have contributed to this accident beyond what the state has argued Mr. Brammer's fault is.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement as we have done the prior two cases. Now turn to the fourth case on this morning's docket. Case number 108930.